is basically saying that because you're a professional and you have a mental health break, you should be treated differently than everybody else. And that is one thing that the justice system should not condone.
Counsel, Mr. Evenson, state represented by Mr. Reichenberg, is here.
He's apparently not, Your Honor. That's Evenson, by the way.
Evenson. You always tell me that.
I do.
Evenson. You have to put 2 E's in the front of your name, not 1.
It's phonetic, Your Honor.
Here's Mr. Reichenberg. This is the date and time for a continued sentencing in this matter. We last appeared here and heard some, we went through a lot of the issues associated with the sentencing procedure, including acknowledging that the pre-sentence investigation report had been filed, whether or not there were changes, additions, or corrections to be made. In addition to that, we had an individual, Andrew Merritt, who was the victim in this case. He provided detailed testimony. He's seeking $10,000 in restitution, $9,859.59, of which is the difference between what his insurance company gave him for the vehicle that was totaled as a result of the accident, and what it's going to cost him to purchase a new vehicle. And then by my calculations, he is seeking another, based on the $10,000 total, $1,864 in gas costs, because the car he's been required to drive since his car was totaled is less gas efficient. And so he's got a total of $10,000. We talked a little bit about that restitution, but one of the bigger issues in Ms. Mitchell's case was the ability for her to do a specialty court because I did not have an evaluation. Since the time of sentencing, Mr. Evenson has filed an evaluation on her behalf. That was filed April 17th of 2024. And since that time, beginning on April 10th, 2024, I have an acceptance letter. I know that she's in mental health court in another county, but now she has a mental health court acceptance letter in this county. Mr. Evenson, I want you to pick up where we left off, but I want you to address for me what the plan would be regarding mental health court. She can't do it in both places.
I have to correct a couple things, Judge. First of all, she is in mental health court in Washoe County. The conviction was out of Churchill County. And she's been doing her mental health court.
You're right. That's the geographic location
Correct.
is here, but I knew the offense was somewhere.
Correct.
Okay.
And then secondly, Judge, you had indicated that Mr. Merritt's insurance company had undervalued his vehicle. And it was in fact Ms. Mitchell's company that, dare I say, did undervalue the vehicle. We, on that issue, Judge, if we can address that first, Ms. Mitchell has been working with her insurance company to deal with that undervaluing of the vehicle. And in probably the most unbelievable happenstance you could happen in this case, in July of that year, or August of 22, I bought my son the exact same car, a year older with more miles, and paid the exact same price that he's asking for. The difference of that $9,000 versus what they paid is exactly what I paid for my son's car.
Okay.
And so we're not disputing the amount of restitution on that issue.
On the price of the vehicle.
Correct.
You are no, Mr. Evenson, I want to take this nice and slow.
Sure.
You are not disputing the $9,859.59.
No, Your Honor.
Okay.
And I believe the district attorney's office, I believe Mr. Reichenberg indicated in passing last time that the difference in gas value is not a valid restitution claim under what we perceive the laws to be. I don't know if the court feels the same way or not, but we're certainly not disputing the $9,800 figure relative to the difference in values of vehicles. Ms. Mitchell has been trying to get her insurance company to pay that difference. It has been sent to a litigation team, and they are reviewing it. And so in the interest of getting this sentencing over with, we would like the order to read that, that the amount be paid either by restitution by the insurance company or by Ms. Mitchell. And if it's by Ms. Mitchell, she would need to enter a payment plan with parole and probation. We anticipate, I had a discussion with them this morning, and I was quite firm that they need to expedite these proceedings, or terms like bad faith and civil suits might occur. And a lot of that, Judge, is based upon my knowledge in 22. I was shopping around for my son's car for quite a while. And I'm very familiar with those prices at that time frame. And there's no doubt that they underpaid the value of that vehicle, and to Ms. Mitchell's detriment, and they have not corrected that yet. So we're really encouraging them to try to correct it. I would hope that Mr. Reichenberg would have no objection to the order being worded in some way that, you know, we don't care where the money comes from as long as he gets it. And if the insurance company says no, then Ms. Mitchell has to pay it. And I don't know if it can be worded that way, but that's what we'd like to do.
Okay, I'm waiting for Mr. Reichenberg on that issue. I have a timing issue with regard to how long the insurance company would take.
Well, I think, Judge, if you give us 30 or 60 days, I'm sorry.
Mr. Evenson, she's going to be on probation for a limited period of time. This is a substantial amount of restitution. And so, I mean, this is going to have to be worked out. If we say 60 days and she has to start paying restitution, but ultimately the insurance company pays, then there's got to be some offset so that she gets her money back. But, right, that's up to the parties. But I do not want to keep the victim waiting, and I do not want to get to a point where she's looking at a $9,000 balloon with 2 months to go in her probationary period. You understand?
I agree.
Okay, all right. All right, Mr. Evenson, anything else?
Your Honor, we would ask that the diversion continue, and that Ms. Mitchell be allowed the opportunities of mental health court and or a drug court type program to continue diversion. We made all of our pitch last time relative to that.
Explain the term continue the diversion.
Well, she's on a diverted sentence from
The other case.
Correct.
Okay.
So in essence, this secondary would run, again, Your Honor, I was not the attorney on the Fallon case. In my humble opinion, having done this for a long time, these cases should have been handled together, even though they were different counties. They should have been set up to run at the same time. That did not happen because of prior counsel's handling the case. And she should have done these mirroring each other, and that's not what happened. And as the court may be aware, when we came in for arraignment, we asked that, you know, we be sentenced based upon the prior PSI and those kinds of things, and that didn't happen. And then we got laid out some other significant times. So when I'm using the term continued diversion, that's what I mean. But it is certainly a new diversion on this case.
Okay, so on her behalf, you are seeking that this court, pursuant to NRS 1768260, place her in diversion so that if she successfully completes mental health court in this case, she's allowed to withdraw her plea, the records are sealed, the offense is over.
Correct.
Okay.
And if the court is not inclined to do that, we would ask for a drug court referral based upon her evaluation of a submitted report on that. In other words, it could be either or frankly both. We're just looking for the diversion option.
Say that again. That didn't make sense to me. You said if I'm not inclined to give her diversion, if I'm
No,
not
if you're
inclined...
not inclined to give her mental health court.
No,
Diversion.
typically when someone is referred to mental health court,
Okay.
yeah, I'm inclined to give it. But you
Okay.
understand that if I don't grant her diversion in this case, I can still give her mental health court as a condition of probation, but a judgment of conviction would enter.
Yes, and Judge, we are asking that that not take place. And again, these are two incidences arising from the same course of conduct that took place in two counties. That is not to say that there's not, you know, statutory and legal authorization for them to be handled differently. But it is the same defendant in both cases. And certainly Judge Stockard and the Churchill County system felt it was worthy for her to have the opportunity to keep her record clean. We certainly feel that for the same incident, just being the beginning of the incident in Washoe County shouldn't change the outcome of the case and allow her the opportunity of diversion.
Okay.
And that's what we feel most strongly about. This is somebody, again, Your Honor, no prior criminal history, mental health break. This is exactly the purpose of the system, is to make sure that without the extreme punishment of a felony conviction on her record, she has the opportunity to get back to being where she was. And that's all we're asking.
Okay. Ms. Mitchell, anything else you'd like the court to know?
No, just that, again, I want the court to know how regretful I am of what happened, and I take full responsibility. I believe the victim should be paid for his car. I'm very sorry that what I did to deprive him of his vehicle and scare him, and I'm asking the court to give me a chance and just let me go to diversion. I'm 49 years old. I've never broken a law in my life. This is the first time. And I truly did have a mental health breakdown. I was hallucinating. I was not in my right mind. Now I know that, and I know what I need to do to make myself better and treat my mental health very delicately and take my medication.
Okay, thank you very much. Mr. Reichenberg,
Yes, sir.
two things I need you to address. I know you came to address other things. I need you to address, obviously, the grants of diversion, number one, and number two, any issues associated with the court giving Ms. Mitchell 60 days in which she would not pay restitution to see if the insurance company will compensate the victim. If they don't, then her obligation for restitution payments begins.
I have no objection to that during the 60 days, to see if the insurance company can or will come up with that money. It is a substantial amount, but either way, those payments are going to be large to get to that $9,000 if the insurance company does not.
Right.
As to the diversion, Your Honor, again, we are asking for 1948 months in the Nevada Department of Corrections. If the court is inclined to give Ms. Mitchell probation, we would actually ask that it be a straight probation with no mental health court and no diversion. Again, with mental health court, the status, as it appears to the state at this point, is that she's basically through that. She's in the end stages. And so I think in balance, the question is, what would be the point of those types of resources in this case?
If I gave her mental health court today, I would require whatever, irrespective of what's happened out in Churchill County, the period of her, if I gave her mental health court today, it would be for a period not to exceed 1 year, but I would require her, require her to be in mental health court on this offense for 1 year.
And I do understand that, Your Honor. So my familiarity with the specialty courts is obviously the phasing that happens, and people are allowed to move to phasing once they've reached certain benchmarks. The fact that she's in the phase that she's in tells me that she has passed those benchmarks. And so I think the question, even if she's there for a year, it's almost kind of like, I would assume, somewhat loose monitoring, given that she's already accomplished those steps. And Your Honor, again, it is not likely that we are recommending a prison sentence, and at the same time, not likely that we are asking that this not be diverted. This was a serious case that put the public at risk, and I understand, and oftentimes in this system, we are trying to get defendants back on a proper course to be productive in society. But again, I was struck, there was argument that we need to get her back to where she was before. And in this case, the state feels that there should be some repercussion, that there should be an ongoing, into the future record of what has happened here, the reckless conduct. Again, in many of these cases, we are looking at people who make the argument that they need a chance, that they need a diversion because of all of life's inequities that were stacked against them in childhood and going forward. In this case, we have an individual who had many gifts that most defendants that we see here never have. And rather than seek help when things were occurring, Ms. Mitchell put the public at risk. And even if the court wants to grant her the opportunity of probation, we still believe that there should be something that this is serious enough, that there should be something going into the future that reflects the seriousness of this crime.
Mr. Reichenberg, I understand that. Thank you very much. It's very helpful. Specialist, how many days credit for time served?
Credit for time served, Your Honor, it's 45 days.
Your Honor, do you need me to respond to anything, Mr. Reichenberg?
If you do, he's going to get the last word. That's the way it goes. And that's even pursuant to statute.
I understand that, Your Honor. I would like to just point out a couple of things.
Go ahead, Mr. Evenson.
Thank you. And I understand he gets the last word with that. Your Honor, nobody's ever argued on this side of the room that this was not a serious case, nor that the public was not at risk by Ms. Mitchell's conduct. But I think the glossing over of the mental health issues by saying that she had a lot of opportunities other people had, she did a lot of things in her life that other people that come before you have not do, is basically saying that because you're a professional and you have a mental health break, you should be treated differently than everybody else. And that is one thing that the justice system should not condone and should not be advocated for by the ones that are elected and that we count on to administer justice in this court every day on behalf of the state. She should be treated no differently than anybody else. We've never come in and talked about the inequities in her life or anything like that. She had clearly a mental health break after 47 years and however many months of consistently good, solid, law-abiding behavior. The system of mental health court and all that is set up specifically to address that. She is welcoming the additional time in mental health court. She is welcoming the additional treatment. She's welcoming drug court if it's necessary. And the idea that this is about somehow flim-flamming the system or doing something like that from the state is in my opinion, in direct opposition to what the legislature and everybody else has set up in regards to those issues. And then, lastly, Your Honor, Mr. Reichenberg indicated that he would assume, based upon his knowledge of the system, that there would be loose monitoring within the mental health court based upon her progress so far. I don't know that the folks in mental health court would appreciate hearing that. I don't think that for his assumption that there's going to be loose monitoring when she's in that court for another year is appropriate and should be considered by this court because there's no evidence of it taking place. Ms. Mitchell has suffered enormous consequences contrary to what Mr. Reichenberg indicates. The loss of her temporarily of her professional license, her ability to make an income, her status in the community, all of the things that come up with being prosecuted for this type of an offense have taken a toll on her. And this idea that there has to be something there to follow her begrudges the idea that it already is going to be following her without regard to what the legal record indicates. However, the law allows for her to have that legal record cleared, and we appreciate very much that you're considering giving her that opportunity in certain circumstances.
Thank you so much. Mr. Reichenberg, you have the last word here.
Thank you, Your Honor. And I will be brief, but first, there's a saying that when you have everything, you have everything to lose. And I understand that where Ms. Mitchell was before this crime was vastly different from where she is today. I take offense saying that we are recommending something different for Ms. Mitchell because she's an attorney. What I'm asking, or was an attorney, what I'm asking is the same thing, and I have stood in front of this same court on a case of very similar facts, someone leaving the scene and asked for prison. In this regard, the legislature has obviously given courts the tools to help people address substance abuse issues and mental health issues. But routinely in this courthouse, myself and my colleagues, when a case of this magnitude comes, we recommend prison and or probation. I personally have handled a number of these cases here and have not seen the diversion. So I take umbrage with the fact that there's some accusation that we are doing something different. With what I said about mental health court, it's been my experience with specialty courts is that when you're in phase one, you come to court every week, you check in more frequently. By the time you reach the upper phases, you are in every couple weeks, then every month. And so I don't mean to say that they don't keep tabs on the people, but what I mean to say is that a lot of the work that happens in the specialty court happens especially in the first few phases, the first part of the program when people are recalibrating their minds and their thinking. And my point is that in this case, she has received that benefit. So again, I'm not disparaging the specialty courts, they are extremely valuable. But what I'm simply saying is a fact. She started out likely going once a week and is now probably going once a month. And so they may start back at phase one. I understand that. But at the same time, the point was more that that intensive type intervention has happened in this case. And so the question is what more can be done on that front. So with that,
Thank you, Mr. Reichenberg. Mr. Reichenberg, does the state dispute that both the Churchill County case and this case arose out of the same facts?
You're right. As we discussed before, it is a chain of facts, I would say. So this event occurred, and then she drove and eluded the officers in Fernley, the Highway Patrol. So it's all a continuing action, I would say, over the course of a couple hours.
That is correct, Your Honor.
I am reviewing the mental health assessment of John Council. Two things about this case. First is she has been evaluated now in 2 jurisdictions and has been declared someone who has serious mental health issues. And in 2 jurisdictions, she's been admitted into mental health court. I have had a case similar to this that involved a lot of violence. Fact pattern, defendant pulls into a drive-through and rear ends another car with aggression, backs up, does it again, backs up, does it again. When the person whose car is being hit gets out, the person driving the car that's rear-ending the other car has a knife and stabs that person, a total stranger. It was a long-term, undiagnosed bipolar disorder that culminated that day at the drive-in. And that type of experience that I have factors into my decision in this case. And in addition, the other thing that factors in is the parties brought to the court a video of what happened here. And it was very troubling, very, very troubling. That you would strike another car and leave the scene was troubling, but that you would drive up Highway 80 in the adjacent to the number 2 travel lane at a high rate of speed in the opposite direction is very dangerous, but I think it's attributable to a mental illness. I just don't understand why someone who was a practitioner for such a long period of time, the discipline that she had come to know over a period of decades with, as I remember, no criminal history, would do something like this. And I also take guidance from my colleague in Churchill County, for whom I have a huge amount of respect. Mr. Evenson, is there any legal reason why judgment should not enter in this case?
No, Your Honor.
There being none, it's the order in judgment of this court that further proceedings in this case are suspended and the defendant is placed in the mental health diversion program pursuant to the mental health court letter accepting her. She is to commence that program from the beginning as a mental health court diversion candidate. Ms. Mitchell, are you asking this court to place you in mental health court?
Yes.
She has a qualifying diagnosis pursuant to the evaluation and pursuant to the order, the letter accepting her. I happen to know that in reviewing the mental health court evaluations, the evaluators do not take lightly a contention of mental health court, and I get more rejection letters than I do acceptance letters. I find based on the mental health evaluation that she has a qualifying diagnosis. Ms. Mitchell, some questions for you. Do you understand that pursuant to NRS 176.260, your program will be for not less than 1 year?
Yes.
Do you understand that the presiding judge over the mental health court, which is Judge Walker, can extend that period to exceed 1 year if he believes that you are not complying with or not complete in all of the requirements of that mental health court?
Yes.
And do you agree to that?
Yes.
Do you understand there's a cost of that program?
No, I did not know that. That's okay.
And if there is, do you agree to pay that?
Yes.
Do you understand that as a condition of your diversion program, you have to successfully complete substance abuse counseling and/or mental health counseling at the direction of the mental health court?
Yes.
And do you agree to that?
Yes, I do.
Do you understand that if you start to violate the terms and conditions of the mental health court, the mental health court judge can impose numerous sanctions?
Yes.
And do you agree to that?
Yes, I do.
One of those sanctions is that you would be brought back here, and that I would revoke you from the mental health diversion court, and we would have a sentencing hearing, and the state would be allowed to argue what underlying sentence should apply in this case, and then I would be in the difficult position of considering placing you in the Nevada Department of Corrections. Do you understand that?
I do.
And do you agree to that?
I do.
It's the order and judgment of this court that further proceedings in this matter are suspended as Mitchell is placed in the mental health court pursuant to NRS 176A.260. She will commence that program anew, and she will be there for at least 1 year, depending on Judge Walker's discretion and her compliance with that program. She will pay an administrative assessment of $25 and a $3 administrative assessment. She has retained private counsel. There is no cost then associated for legal fees. The program will be for not less than 1 year, which may be extended by Judge Walker as he deems appropriate. She will abide by the rules and conditions of the diversion program. She will enter into and successfully complete any substance abuse or mental health counseling that the Division of Parole and Probation believes is necessary, because she is simultaneously supervised by the Division of Parole and Probation. We do that, Ms. Mitchell, and you may know this, but you will get a supervising officer if you don't already have one through the Division of Parole and Probation. The mental health court cannot come to your house at any hour of the day or night and search your person, property, in the place that you're living, but the Division of Parole and Probation can. That is a condition of your probation. You will submit your residence, person, property in any area under your control to search and seizure without a warrant by the Division of Parole and Probation or its agent to determine whether or not you're complying with the terms and conditions of the program or committing additional crimes. You will abstain from the use, possession, or control of any alcoholic beverages and controlled substances, to include marijuana and weapons, during the entire period of your supervision. You will submit your blood, breath, or urine to random testing at the discretion of the mental health court to determine, and the Division of Parole and Probation, to determine whether or not you're using alcohol or controlled substances not prescribed by a treating physician. Ms. Clerk, I have a restitution in this case. Restitution in this case is ordered. It's in the amount of $9,859.59. She does not, Specialist Tui Halanengi, she does not need to start paying that for a period of 60 days, during which her insurance company is going to be given an opportunity to compensate the victim in this case. If that does not occur, she needs to start periodic payments to ensure that the restitution is paid. All right? And bear in mind that giving up the 60 days is 2 months, so we're even shortening the period of her opportunity to pay if the insurance company doesn't pay. Now, if she starts paying and the insurance company then pays, she's going to be entitled to reimbursement from the victim for the amount that she paid. Understand? So that he's not paid more than $9,859.59. Ms. Clerk, did I get everything? Oh, you will appear in mental health court. When is your next? You're going to appear.
My next two.
Yeah, we're gonna have you appear. Ms. Clerk, what day is she appearing in mental health court for her intake in this case?
April 30th at 2 p.m. and she is to immediately report to room 127.
Right now.
Right now.
Yes.
127?
And Your Honor's jurisdiction transferred?
Jurisdiction is transferred
Bail
to
is
Judge
under it.
Walker. Yeah, are you out on bail, Ms. Mitchell? Or are you on your own recognizance?
I'm out on bail.
Bail's exonerated.
Thank you, Your Honor.
Thank you, Mr. Evenson, Mr. Reichenberg, Ms. Mitchell.
Thank you.
Let's go with CR 23-0310, State of Nevada versus Adams.